My name's Andrew Gallie, and I'll be joined by my colleague Bronwen Jones, and we'll sort of be walking you through what we think are the important data protection issues over the next hour or so. Now, it's going to be a busy year for data protection compliance. So you've got the Data Protection and Digital Information Bill, which is set to reform all aspects of data protection law, and some key ICO guidance, in particular around employment and employees, being published as well. So as ever, what we're going to cover is a mixture of what we think are the key risk areas in the HE context, as well as these important updates. Now, the session is being recorded, so there'll be a recording available on our YouTube channel in the next couple of days. Please do ask questions. If you pop your question into the Q&A box, we'll then hopefully have time towards the end of the session to answer your questions. So in terms of what we're going to cover off specifically, Bronwen's going to start us off by talking about subject access requests, and this is probably the most lengthy part of the talk, simply because so much of the work we do for HE involves SARs, and people inevitably have questions about sort of strategy and approach. So we'll let you know our latest thinking. I'm then going to look at the implications of artificial intelligence and data protection. I'll then give an update on some things around international data transfers before we'll finish off and give our thoughts on the Data Protection and Digital Information Bill. So I'll now hand over to Bronwen, who's going to talk about subject access requests. Could we have the next slide, please, Greta?
Hello, everyone. As Andrew said, I'm going to talk about subject access requests this morning, and in particular, a focus on top tips and reducing the workload where we can, how to manage them, things that we found to be quite useful when going through the process of receiving a subject access request. Greta, could you have the next slide, please? Thank you. So just some initial considerations to start off with then, and things to think about, so maybe before you've even received a request. The first thing is that the right belongs to the data subject. And what we sometimes see is requests coming in from third parties in an HE context, in particular from concerned or worried parents who might feel that they're still entitled to access their child's data. Or sometimes, if you've got it in the context of a staff grievance, a friend or family member who acts as a representative, perhaps they are a lawyer, they know a lawyer, something along those lines, they might make a request on behalf of the data subject. Now, if you do receive a request, it's important to remember that the right still belongs to the data subject. So you do need to satisfy yourselves that you've got their authorization. If you received a request, for example, from a solicitor, we're a regulated profession, so hopefully trustworthy. As long as you've got an authorization form or something along those lines where it looks genuine, you've got a signature, you can be fairly satisfied there that you've got the authority. Where it comes from someone who's not part of this regulated profession, so a layperson, friend or family member, you need to do a little bit more, I think, to satisfy yourselves that the request is genuinely authorized by the data subject themselves. What you don't want to do is get into a position where you've tried to be too helpful, but you've accidentally released data to someone who doesn't really have authority. So the suggestion for those sorts of requests would be to ask for an email that comes directly from the data subject themselves, or a telephone call or something along those lines, but to just carry out an additional extra step there to make sure that you're fully satisfied that the authority exists. If you've got a request that comes from the individual themselves, in some circumstances, it will be really obviously definitely from them. So if you have a request from a member of staff and it comes from their university email address, you can be fairly sure that that's come from them. And so there's no need to really carry out any further checks or ask for ID. The position's slightly different where, for example, a former student might make a request. So they probably don't have their university email address anymore. They'll be corresponding from a personal email address, it may be different from the one that you have on file. For example, it could be from their work. In those circumstances, you may want to go back and ask them to provide further ID. You don't need to go over the top, so not sort of bank style checking, but just enough so that you can match it up with what you've got on the system to make sure that you're, again, 100% certain that this is the person who they say they are, and you're not going to be releasing information to someone who's fraudulently trying to make a request for someone that they're not. When you ask for ID, the time frame for responding doesn't start running until you receive the ID. And that's the same point with the authority as well from the third party request. And that's because until you have the ID or the authority, you don't actually have a valid request because you aren't certain that it's come from the data subject themselves. So you calculate your deadline from the date that you receive the ID or the authorization. And up until that point, that's not an active clock running. After you've asked for ID, after you've got your valid request sorted, the next step is to think about whether you need to ask for clarification. And I will cover this as well when we come to look at searches. The point of clarification is to help you to find the personal data that the person is seeking. We've all received those requests where it's an everything that you hold on me type request. If it's for someone that you've had very little dealings with, that might be absolutely fine. But if it's for a member of staff where they might have worked there for 20 years, clearly that's going to be incredibly unreasonable for you to pull all of that information and search through it. So the obligation is for you to carry out a reasonable search. Asking for clarification can help you to put together what that reasonable search looks like, because the intention is that the requester will provide you with more information, which will then inform your search terms. For example, a time frame that they're particularly interested in, or people's mailboxes that they want you to search. So our suggestion for the clarification when you go back and ask for it, if you need to, is to draft the clarification email or letter in such a way that you give examples of the types of things that will be helpful for you to know, to try and steer them to provide the information to you, which would then inform your searches. You're allowed to go back and ask for clarification, but they're not legally required to provide you with the clarification. So our recommendation for getting that useful response from them would be to go back very promptly where you can. So rather than waiting until you're almost at the end of the 1 month, try and go back as promptly as you can with something helpful for them to steer them down a path that gives you the search terms. I've just said there's no obligation for them to respond. And we do sometimes find that people come back and say, no, I want everything that you hold on me. That's my right. That's what I want. In that situation, you'll be in the realm of doing reasonable searches, which I'll come onto on the next slide. The time limit pauses whilst you're waiting for a response to the clarification email or however you've sent it. So if they took 9 days to come back and respond, then you can add 9 days onto your deadline there. If they don't come back at all, so you just never hear anything from them, you don't need to start doing your searches. You can just leave that one, park it, and the ICO guidance on this says it's reasonable after about a month to close that down and just leave the request and wait for them to come back. In the absence of them providing anything at all, if they do come back and say, no, I want everything, then proceed on a reasonable search basis. Calculating the deadline, and people really do get in a muddle with this, especially when you've got FOI, which is a different process as well. So it's a 1 calendar month deadline from the date that you receive the request. So if you received a request today, so the 11th of January, you've got an email in your inbox that says, please provide me with all the personal data that you hold. The deadline for responding to that would be the 11th of February. So exactly 1 calendar month, you just take the same date. The 11th of February this year is actually a weekend. So because it falls on a weekend, your deadline rolls over to the next working day, the Monday. So if it fell on the Saturday or the Sunday, the Monday following is your deadline there. If you'd asked for clarification, it would be 11 plus 9 days. So that would take us to the 20th of February. So you work it out in that way. Please may I have the next slide? Okay, so preparing the response. Let's say you've been through all of your process, you've got your clarification. The next step is to search for the personal data. This is an incredibly key step because whatever you do here will inform the scope of the task that you're required to carry out when you come to exemptions and redacting, which I will come on to. As I've said before, the obligation is to do a reasonable search for personal data. Now, what we're finding is because higher education institutions hold such a vast amount of information, it's quite possible for what you think to be a narrow search to be absolutely enormous in terms of the results that are being generated. So I really would recommend at the outset sitting down with your IT team and anyone else who might be relevant. So let's say it's a staff request and it's come from the context of a grievance. Sit down with whoever in HR is handling the grievance, the IT team, have a look at what the request actually says and work out what your search terms are going to be based on what's technically possible and what you think the requester is looking for. And it might be that you use a combination of different approaches for different elements of the request. For example, if they've asked for their personnel file, well, that's relatively easy. You can just go and get that. If they've asked for things in email accounts, are you doing targeted mailbox searches? Are you using keywords in conjunction with the requester's name? How common is the requester's name? If it was John Smith and you've had millions of those over the years, then you might need to be doing it in a more targeted way. For example, well, it's this person that attended between these years, so we'll target it to these years rather than across the whole system. So trying to use what's available to you to ensure that you don't get lots of irrelevant results pulled into your search there, which should cut down on the time that you need to spend actually reviewing it. The other point to note, and this is particularly relevant for staff requests, is not everything that has a staff member's name on it will be their personal data. So where you've got someone who is, for example, a named document owner, and that's the sort of thing that might be pulled back by a search for their name, you might end up with a whole pile of materials that are nothing to do with the staff member, that are just things that they've maybe saved in different areas as a document owner, someone who's in charge of keeping track of where things are filed. So again, making sure that you're trying to target your searches and understanding what types of information that you hold to try and avoid having to sift through the irrelevant, not personal data things. Similarly, where they're just emailing about, I don't know, please find attached the course materials or something like that, normally that wouldn't be their personal data because it's just them doing their everyday job. So trying to find a way of excluding information such as that, which you know just isn't going to be personal data or isn't what they're looking for because they want the things they haven't seen before, will be really important. Also, bearing in mind exactly what they've requested. So making sure that you're not being too diligent and trying to provide everything, whereas actually they've made quite a narrow request, which means you can just do the search for what they're looking for. And I know this sounds really obvious, but so many times we look at a huge data set and say, but all of that, that's not what they were looking for. So we don't even need to look at that. And people have just been too diligent in trying to be too helpful. So keep a copy of the request next to you when you're having those chats about searches. Don't forget that the cutoff date for your searches is the date that you received the request. So using the 11th of January example, today would be the cutoff date. So even if you don't start your searches for, say, a week or 2 or 3 because you're waiting for clarification, you still only need to cut the search date at the 11th of January because that's what the entitlement is to. If they wanted to make a further request for further information after that date, they could, but it's not sort of rolling for the whole time that you're trying to prep the response. social media and personal devices. And this really does come up in an age of social media. So the position with this is you only need to search personal devices if you have a reason to believe that personal data that falls within the scope of the request could be found there. So, for example, if your general approach is that you permit staff members to use WhatsApp on their personal phones for work purposes, so to arrange one-to-ones with students or to discuss, I don't know, line management with their employees, then you might need to search their personal WhatsApp. But generally speaking, unless you think there is personal data there that falls within the scope of the request, you don't need to be asking people to search their personal devices. If you have work devices with things like Microsoft Teams chats on, that's a bit more reasonable to do a search on there, because that's really where people are supposed to be carrying out their work conversation. So even though it's a chat type function that's similar to WhatsApp, it sort of falls under the bracket of Outlook and things in terms of being part of your personal data that you're data controller of. So slightly different depending on whether it's a personal or work device there. Extending the time frame, you are able to extend the time frame for responding by up to an additional 2 months, which I think everyone's probably aware of at this point. That's based on whether or not the request is complex. So if you have a complex request, then you can extend by up to 2 months, as long as you tell the requester within the original 1 month period of time that you are doing so, and you need to provide them with the reason that you're extending and that you think the request is complex. So there's no sort of legal definition of what a complex request is, and it very much depends on what the context of the request is. The ICO does have a helpful section in its subject access request guidance, which lists about 6 factors which might indicate that a request is complex. So if you're unsure, that's a good place to start to go and try and see if any of those factors apply to your request. Just listing a few here. Clarifying potential confidentiality issues around disclosure of sensitive medical information to an authorised third party. So when you're dealing with medical data, just bear that in mind if the request is specifically for that. Needing to obtain specialist legal advice. So if you come to us to ask us, then that can indicate that the request is complex as well. However, if you routinely obtain it, it might not be complex. So just to bear in mind. Also technical difficulties in retrieving the information. So if, for example, you're looking for stuff that's been archived and you're unarchiving it for a former student or something along those lines, then that can indicate a complex request as well. A request, unfortunately, isn't complex just because someone's requested a large amount of information. And this is where it links back to doing good searches, because rather than trying to extend based on, oh no, we've got 21,000 hits on our search result, which wouldn't, strictly speaking, indicate a complex request, using the searches to cut it down to avoid being in a position where you feel as though it's going to take longer, so you want to use the extension. Also, a request isn't necessarily complex just because you have to rely on a processor to obtain your information. So if you've got a management information system or a third-party software app that you use and you need to go and ask them to retrieve the data, not necessarily complex because you're doing that process. So you need to inform them within the original 1 month and give the reasons. Giving the reasons can be a little bit difficult depending on what your reasons are. For example, if you've sought legal advice and that's really your reason why you're extending, you wouldn't normally want to be telling requesters that you've sought legal advice, purely because it escalates the SAR in their mind. Normally, subject access requests come out of some kind of complaint, grievance, issue. There's something else going on. People don't normally make requests just because they're interested. So referring to legal advice can sometimes cause a requester to think, fantastic, there's something in whatever I'm pursuing here. I'm going to keep pursuing it. So it escalates the whole thing in their mind. So a carefully drafted extension notification is really important to make sure that you are covered in terms of you put enough in there that you can claim the extension, but you haven't accidentally created a problem for further down the line. So really a balancing act of how you draft those there. Once you have your search results and you're ready to carry out your detailed legal review, is what we would call it. So going through, redacting, however you want to present it. One of the things to bear in mind is that the right of access is subject to a number of exemptions, which can be found, broadly speaking, in the schedules of the Data Protection Act. So just because something is someone's personal data doesn't necessarily mean disclose to them if there is an exemption that applies and it's something that you want to utilize. The most common exemption that we find to be used is the exemption for third-party personal data or mixed personal data. So where you have personal data of the requester, but also of someone else. So for example, John and Jane were disruptive in a seminar today, so I asked them to focus. So let's say that Jane has made a request, but there's some of John's personal data in there. This is what we call mixed personal data. The position with this is that you shouldn't disclose third-party personal data unless, and there's two elements, either you have the consent of the other individual. We wouldn't normally recommend going to seek consent, although there can be some circumstances in which it's appropriate. Or it's reasonable to disclose the personal data in all of the circumstances. And what reasonable looks like really depends on the context of the request and the situation in which it's been made. So if you've got fairly anodyne information, for example, about a husband and wife who've come in to attend a meeting together to talk about grant funding or something along those lines, they've both been in that meeting together. They both know what was said, even if only one of them's made the request. That's the sort of situation in which it might be reasonable to disclose some of the third-party personal data. Where it would be wholly unreasonable is where you've got, for example, a student who's made a very serious allegation against another student, and the alleged perpetrator makes a request to find out all of the information. And if it's an incredibly sensitive subject, so assault or bullying or something like that, that needs a very careful look through to decide what you're going to disclose. And the mixed personal data exemption is there if you need to withhold information, particularly if it's information that's not already known to the requester. So it's going to be new news to them. Doing the balancing exercise between their right to their personal data, but the other individual's right also to privacy and not to have their personal data disclosed. A word of warning as well with doing the review, just because something has someone's name in it at the start, people sometimes forget that further down an email, for example, it might stray away from being their personal data. So it could start off with someone making an allegation about a member of staff, but then the email could turn into them just generally talking about how they feel, whether they've had mental health struggles, unrelated topics. So making sure to take out anything that isn't the personal data of the requester at the same time as going through and applying your exemptions. Similarly, email subjects. I've noticed a lot of multiple names in email subjects because people want to talk about different students perhaps. Making sure that you don't forget to look through the email subject as well to take out anything that's unrelated to the requester so that you don't inadvertently disclose personal data of another person. Redacting the name alone is likely not sufficient. And I know there are tools out there that say you can just give them all the names that you want redacted and it will automatically spit that out, and it's a huge time saver. Just taking out the name quite often will not remove the personal data, particularly where you're talking about a contextual situation where you've got multiple people who all know all the facts of the situation and therefore they know who's who. So it would be obvious even if you took the name out. You might need to take out whole sentences based on the mixed personal data exemption, or maybe even extract to a separate table. And you are entitled to do that. You don't have to present the information in its source document. The entitlement is to a copy of the personal data rather than to the original document itself. So if you've got very mixed personal data, and it would be easier for you to put it into a table so that you can sanitize it of other people's data, then you are perfectly entitled to do that. And it's much better to do that than try and redact a name only to realize that it's very obvious that there are other people involved there. The higher risk is disclosing something that you shouldn't rather than withholding too much. So where the reprimands and where the ICO really care about things is if you've disclosed too much information rather than withholding something. As long as you've got a good exemption-based justification for withholding with a sensible argument, then that's the much safer solution there. Another exemption that we found to be quite useful at the minute is the confidential references exemption as well. And that applies both to the person who's given the reference and the receiver of the reference as well. It applies as long as you have made it clear that the reference is kept in confidence. So it needs to be a confidential reference. You need to make it clear to data subjects really as well that you're keeping their references in confidence. And the easiest way to do that is to include a line in your privacy notices that says references will be held in confidence. And that way, if anyone ever queries the approach, you can refer back to the privacy notice and say, look, here, you were notified, we've been transparent about it. This is in both staff and student privacy notices because it applies in both an employment and also an education context as well. So perhaps worth a look to check. If that's your approach to keep references confidential, then a look to check. You don't have to apply an exemption just because it exists. You have discretion there. So if you'd rather say, no, we've nothing to hide and we prefer to disclose references, that's fine too. So just depending on what your approach is, making sure that you're aligned and it's consistent across the board. When you're applying your exemptions, we recommend keeping a record of all of the exemptions that you've relied on and really to which pieces of personal data, so in a very granular way. The application of exemptions is a granular process. It's very rare that you would just say this whole document is out based on one exemption, because what you want to do is go through and look at each piece of personal data and decide what you're disclosing. So a detailed record of exemptions is really important. If someone does complain to the ICO, and I will come on to complaints shortly because they are a reality, if someone complains to the ICO, it will save you so much time if you've got that record of exemptions, because you can just pull that back out. And sometimes complaints take months to come around as well. So I mean, I've forgotten, 2 weeks after you've done a request, it's sort of, thank goodness for that, we've sent it, it's gone. So just a nice refresher for you rather than having to go back and almost redo some of the work and the understanding of what you did. Also, if things change hands, so if you have someone leave or if someone goes off on sick leave or something, then the record still stands. So you're not having to try and look at what someone else has done and work out what their thinking was, because you've got your record there and it's just really clear why you did things the way that you did them. Okay, so a few practicalities here then. You may have seen the ICO guidance for employers on subject access requests. I just want to run through, it's done in sort of a Q&A type style, and I just want to run through a few of the ones that I think are really useful. The first one being, do you need to inform the requester of the exemption that's been relied on? Legally, no, there's no legal obligation for you to tell requesters. However, the ICO response to this is that it depends on the circumstances of each case. And if you can be transparent, then you probably should be. However, in some situations, it would be wholly inappropriate to tell a requester which exemption you've relied on, because it would prejudice the purpose of the exemption. So in some cases, if you're relying on one where there's a risk of harm to the individual, to tell them about that might undermine the rationale behind relying on the exemption. So no one size fits all. Depending on your request and which exemptions you may want to tell the requester. If someone has only asked for their reference and you are saying, no, sorry, we're not going to provide this to you with the confidential references exemption, it makes complete sense to go back and tell them that that's the exemption that you're relying on, because otherwise you're just saying, no, we're not providing it to you. And then they'll say why. So you may as well get ahead of that and let them know which one. Treat each request as an individual and decide what's right at the time. And if you're unsure, we're always happy to advise on whether or not it would prejudice by letting them know about the exemption. What to do about limiting subject access requests in settlement agreements. And this does come up. So I know that people make subject access requests in the context of employment disputes. This has been going on forever. One of the terms of a settlement agreement that's really attractive for employers is to ask them to withdraw their subject access request because things have settled and they'd only made the request anyway to try and fish for information. The ICA's position on this is that the right of access can't be overridden by a settlement agreement. So essentially it would be an unenforceable provision there. It doesn't mean that people won't still put them in and agree with requesters, look, withdraw your request and then this is all wrapped up and let's get it in the settlement agreement as well. But if it were to be challenged, the likelihood is that it would be unenforceable. So just a bit of a health warning around those to say they're not watertight in terms of enforceability. And then on a similar note, subject access requests and tribunal proceedings. So what to do with, you've got the disclosure process running alongside the subject access request, and they are two separate processes. So even if you've already given the information as part of a grievance or a tribunal process, the right of access is separate. So strictly speaking, you do need to provide the information again. Also, not forgetting that what they're entitled to under the right of access is completely different from a tribunal process because it's just a copy of their own personal data. So actually, you normally get less under a subject access request. It's frustrating having to comply with both. You can try and have a conversation and say, look, you've actually already got copies of these unredacted because you've had them through this process. So we'd be providing you with less information, but ultimately they are still entitled to the copy of their personal data there. CCTV footage requests as well, really difficult. Normally lots of mixed personal data, especially in busy corridors or, walkways or whatever, it's very tricky to manage them. You don't want to be disclosing other people's personal data and providing someone with a copy of that video because that's privacy intrusive and not fair to the others. So one option is that you can invite them in to view the footage rather than providing them with a copy. So they come in and view it in person. As long as the individual agrees to that approach, then the ICO's view is that that's absolutely acceptable and fine. And in our experience, some requesters are quite happy to do that because they just want to see it. They don't really want the copy for their own purposes. If you are going to do that, just make sure they're not covertly recording it to take it away with them. And that sounds really cynical, but we live in the age of smartphones and people do record things. So try and make sure that it's not being covertly recorded. If they do insist on a copy, then you need to think about whether you can actually comply with that. If you are able to blur or redact people's images, if you've got that software capability, then that's the safest approach. If you aren't able to do that, then it's either a case of providing stills with blurred or redacted, or not providing it at all and using the mixed personal data exemption because you need to consider the privacy of others and your technical capabilities wouldn't allow you to disclose it. Okay, some practicalities. How are you providing the information? Are you providing it electronically? If they've made the request electronically, then that's the obligation unless they specify otherwise. Suggest doing the review electronically if that's the case. printing it out and scanning it back in is very time consuming and often can reduce the quality. I just wouldn't recommend. So an electronic review gives you searchability function and it allows you to make amendments more easily. So that would be my recommendation. How many reviewers are you going to have? Ideally, one reviewer, only for the reason that duplication exists, as we know. You don't want to be preparing the same piece of personal data differently. So two different people review the same piece because it's duplicate in the bundle. You can end up with there being a discrepancy between the way it's prepared. And this is a big risk because a requester will see that and will query that approach. So one reviewer helps to prevent that. But understandably, with resources, you might want to use more than one reviewer. If that's the case, think about how you're going to split the bundle. I'd suggest doing chronological and using dates to split it, but making sure that you're mindful of attachments that might have started off as an original in one person's chronology, then been attached to an email which falls into another person's chronology. So just making sure you keep an eye on the dates and an open dialogue. Ultimately, coming up with your strategy for exemptions and approach beforehand will save you a lot of time as you're going through. Be aware of drafts, in particular draft emails and draft documents. The position with drafts is you only need to disclose personal data, which is new in the draft. So check through your drafts and see if there's any new personal data. If it's complete duplication, it can come out. Please may I have the next slide, Greta? Other points to consider. So refusing to respond, which I know a lot of people want to do because SARs can be a nuisance. The current position with this is you can refuse to respond if the request is manifestly unfounded or manifestly excessive. Unfounded is where the requester has absolutely no intention really of exercising their right. So they're just doing it to be a nuisance, to harass the organisation. They've got a vendetta against a particular employee, or they offer, for example, they offer to withdraw it in return for some kind of benefit. So can I have a promotion? I've made a subject access request, promote me and I'll get rid of it. Excessive isn't necessarily to do with volume, unfortunately. It's to do with requests that overlap and repeat with other requests, or there's not been a reasonable amount of time that's elapsed between requests. So the bar is pretty high on both of those at the minute. I will briefly mention that there is going to be currently in the Data Protection and Digital Information Bill, the Reform Bill, there's a provision around vexatious requests, which might be of some assistance, which is to do with whether or not they are sort of trying to be a nuisance a bit more, basically. So at the minute, you've got unfounded or excessive. Hopefully in the future, there'll be a bit more ability to refuse requests there. People almost always complain to the ICO. Just as a word of reassurance, it's completely free to complain, so people do. Generally speaking, the ICO take a while to look into the complaints, and normally they ask you to respond to them informally first. So suggest that you try and do that before it gets to the point of the ICO. So if they've come back and said, where's the stuff, you can try and resolve that informally. The reason people complain is because they don't have a good understanding of what they're entitled to. So what they get looks very different from what they're expecting. As long as you've got good record keeping and you've followed the process that I've just described, you should be able to explain to the ICO why you've done the right thing. The ICO does publish reprimands. So there is a sort of a slight concern around someone making a complaint and it being published. However, in my experience, short of failure to respond to a subject access request, you're unlikely to be reprimanded as long as you've got good justifications for everything that you've done. So all of the practical things that I've just said should help you to, if not avoid a complaint, at least be able to justify and avoid any criticism from the ICO there. So I've just mentioned the Data Protection and Digital Information Bill, the Data Reform Bill, which Andrew will cover in more detail. I've talked about vexatious requests that are an abuse of process. It remains to be seen how the ICO will interpret this, because arguably all all subject access requests are an abusive process. So we will see how that develops, but fingers crossed it might provide you with a bit more scope to refuse. On top of that, they're going to put into law the bit around reasonable searches. So I've talked about reasonable searches in detail. That comes from case law at the minute. The current draft of the bill puts that into the statute itself. So it doesn't change the position practically, but it just gives you a bit more of a bolster from the statute itself, which hopefully should provide a bit more comfort and reassurance when you're carrying out your searches. Could I have the next slide, please, Greta? So just to summarise, prepare to receive the request. So make sure you've trained all of your staff on everything that we've talked about. Anyone that handles personal data and might receive a request can come into anyone. It doesn't have to be made to one individual. So train everyone how to recognise a request, come through social media and all of that. Make sure you get your searches in order. That will save you so much time. And make sure you've got your data retention sorted so that you've got less information to look through. The less that you're holding, the less that's likely to come up. So retention periods combined with searches will be really useful. I'm now going to hand over to Andrew to talk about artificial intelligence.
Thanks very much, Bronwen, for that. So grab the next slide, please. So I'm going to just give some thoughts on the data protection implications of using artificial intelligence, just based on the work that we've been doing recently. Can I have the next slide, please, Greta? So interest in AI has obviously exploded over the past year or so, helped no doubt by things like ChatGPT, which has sort of captured the public's imagination. And I'm sure we've all had a play with it, and we've all have our own views on how accurate we think it is and the benefit. But I think whatever our views, whatever our personal views, AI is here to stay and is going to sort of revolutionize our most aspects of our professional lives. Before we dive in there and think about some of the data protection issues, I just want to sort of cover what do we actually mean by AI? And there are loads of definitions available, but in essence, it means using a computer to do something or to make a decision that would usually require human intelligence. And I know certainly in the university and the HE context, AI is being used in all sorts of different ways in relation to education, to research, and also in relation to business operations as well. And many universities are offering undergraduate courses that include a heavy AI element. I mean, in terms of what the uses might be, I think the sky's the limit. So you might, for example, be using AI as part of the research project to extract insights into the information in a far more quickly and far more efficiently than for a human review. You've got in the healthcare context, for example, there's loads of stories in the news right now about how AI is being used in the healthcare context, in particular medical diagnosis, to look at X-rays, CT scans, and so on. You could use AI to spot patterns of concern, for example, in terms of how students or staff might be using your IT, if there's something that sort of represents a risk to them or to others, or to develop a personalized learning plan for students based on how well they're doing in assessments and so on. So there are huge opportunities here. But as ever, these things engage with data protection, and we need to be making sure that we're using AI and exploiting it in a compliant way. Could I have the next slide, please? So I've set out on the slide here what I think are some of the key data protection issues we're thinking about when using AI. And my first point, to give a slightly obvious point, but as a first step, I think we should just be thinking about, do we actually need to use personal data when we put it into the AI model? If the information can be anonymized, or even with some identifiers removed to reduce the risks, then that will go a long way to eliminating or to reducing some of the data protection risks that we're going to be talking about. But if we are uploading personal data into the platform, then we need to be thinking about the data protection principles the same way we would with any other data processing. So, for example, we need to make sure that what we're doing is fair. If we're using AI in a way that is unlikely to be fair on people, then that's unlikely to be compliant. We need to comply with the accuracy principle. So GDPR says we need to take every reasonable step to make sure that the personal data we process is accurate. So if, for example, you are using a platform, let's say you get loads of applicants for a particular job, so you're using some software to screen out applicants who don't meet the minimum requirements. If you're finding that that will very occasionally reject someone who meets the criteria, you have to think about what you can do to mitigate the risks. For example, giving people an opportunity to object if they think that the minimum criteria hasn't been met. You should also be thinking about transparency, and as I'm sure we all know, under data protection law, we're required to give people information about how their personal data is used, and this this is usually provided in a privacy notice. Now, interestingly, the use of AI does not by itself trigger an obligation to put extra information in a privacy notice. So there's nothing inherent with AI that says you've got to sort of make changes to your privacy notice, but in practice you often will, particularly if you're using people's personal information in a way that they might not reasonably expect. Okay, so if the personal data that you're using in connection with AI, if you're sharing it with third parties, then you should be thinking about what you need to do in terms of that sharing. And as I'm sure you all know, everyone under data protection law is either a controller, a joint controller, or a processor. And so controllers get to make the key decisions about how and why personal data are used, whilst a processor must only process personal data on the instructions of its controller. So if, for example, you are doing a joint research project with another institution that involves creating some software that will be used in medical diagnosis, any personal data used to train that model, you're probably going to be joint controllers. Thinking about off-the-shelf generative AI platforms such as ChatGPT, do you think ChatGPT are a controller or a processor for the information that you might input? Well, certainly there should be a processor if all they're doing is using the information to provide an output for you. But the issue is these platforms will often use the information that you input for their own purposes. For example, to develop the AI model and to inform the answers it gives in future. And arguably that makes them a controller, which obviously raises sort of additional data protection and privacy risks. However, you can get versions of GPT that will ring fence your data such that it doesn't leave the sandbox that you've created. So the data isn't then used more widely within the GPT platform. And that's definitely something worth considering if you are going to be using one of these platforms. And as ever, the greatest risk, in my view, in terms of data protection compliance is around data security. The vast majority of data protection fines, compensation claims come about through data security breaches. So you need to make sure that your use of the platform is compliant and that you've got appropriate measures in place to safeguard the personal data. So if what you're doing counts as automated decision making, then there are extra things to think about. And so Article 22 of the GDPR says that you need to take extra steps if you're doing what's called solely automated decision making that has a legal or similarly significant effect on someone. So essentially, this means using a computer to make an important decision about someone without any human input. And automated decision making and AI are not the same thing, but there is a big overlap. So, for example, if you had a piece of software that would sort of spot patterns that would suggest plagiarism, for example, and if those concerns that then went to a member of staff for a human review, that's arguably using AI, but that doesn't qualify as automated decision making. The example I mentioned earlier on about using some software to screen out applicants who don't meet minimum criteria, that is automated decision making. So there you need to be thinking about both sort of things from an AI perspective and thinking about your obligations under Article 22 as well. And essentially, if Article 22 is engaged, then you've got additional obligations. For example, you need to tell people what you're doing so that they have an opportunity to make representations. And you can only do it in limited circumstances. For example, if it's necessary for entering into a contract, or you've got the individual's consent. Okay, next slide, please. Okay, so moving on then, I just wanted to give an update on international data transfers as well. And I know that there's been quite a lot of interest in this from the ICO over the past couple of years, partly fueled by Brexit and all the changes that sort of brought in. So I'm sure everyone's probably sick to the teeth about hearing about international data transfers, but there have been a couple of helpful developments over the past couple of months that I wanted to share. Next slide, please, Greta. But before I do that, I just wanted to very quickly just remind everyone of what the GDPR says. So you can only transfer personal data to a controller or a processor based overseas if one of three things apply. First, it's going to a destination country that has an adequacy decision that covers the transfer, and most EU member states, in fact, all EU member states, plus some other countries, have the benefit of adequacy. If there's no applicable adequacy decision, then you can make the transfer if it's subject to a safeguard. And the safeguard that usually applies, certainly in the HE context, is that you've contracted on the ICO standard clauses for international data transfers. There are two sets of clauses available. You've got the IDTA and also the addendum, which sort of acts as a bolt-on to the EU standard clauses, the EU SCCs, and makes the EU SCCs work in a UK context. And in addition, you need to do a transfer risk assessment in addition to using the safeguard, so in addition to the IDTA or the addendum. And then the third situation where you can do the transfer is if it's if an exemption applies. The exemptions are fairly limited in scope. But for example, imagine you had a member of staff who fell ill whilst on a field trip to Brazil. If they're unconscious, they're in hospital, the hospital needed medical information about them, you'd be able to obviously provide that under one of the exemptions. So you wouldn't be worrying about data protection in that context. So those are the rules in a nutshell. So what's changed? Can we have the next slide, please, Greta? So first, there is as from 12th of October, there is now an adequacy decision that makes it lawful to transfer personal data to recipients in the United States, so long as the recipient has signed up to the scheme. The scheme is called the US-UK Data Bridge. And so if the recipient has signed up, then and their registration covers the transfer, then you don't need to be worrying about IDTAs or any of that sort of stuff for international data transfers. Now, to find out if you you can look on the there's a website that sort of lists which US organisations have signed up to the scheme. So I suggest that you check that. If you just Google DP framework list, that should bring up the website, and then you can check that your recipient is signed up to the scheme. So this should make international transfers to the United States a bit less difficult. Now the second development is this. So if the party that you're sharing the personal data with hasn't signed up to the data bridge, then you still need to use a safeguard such as the IDTA or the SCCs, and you still need to do a transfer risk assessment. Uh, the However, the ICA produced some guidance just before Christmas where they said that for transfers to the USA, you can rely on the risk assessment that was done by the government, acting through the Department for Skills, Innovation and Technology, which the government did as part of setting up the data bridge. So in other words, you don't actually need to do a proper TRA for transfers to the States anymore. And instead, you just need to document that you're relying on the assessment that's already been done by the UK government. So it does make things much easier. And also, the ICF clarified that you can do this even if the personal data you're transferring to the States is high risk. So it does make, so taken as a whole, it's just going to make transfers to the United States much more straightforward. Okay, next slide, please, Greta. Okay, so the final topic that I want to cover is just some thoughts on the Data Protection and Digital Information Bill, and what this might mean for HE. Can we have the next slide, please? So this has been sort of kicking around for a couple of years now. It was originally introduced a couple of years ago. It was introduced in its current form in Parliament last March, and it's sort of been going through the process ever since then. It's currently with the House of Lords. This is set to reform all aspects of data protection law. So both the GDPR, the Data Protection Act, and also the privacy regulations, which sort of govern electronic marketing. And it's very unique in that it's the first piece of data protection legislation ever in the UK to have the stated purpose of making people's lives easier rather than making them more difficult. So its stated aim is to reduce the regulatory burden, and the government has claimed it will lead to efficiency savings and savings businesses totaling £4.7 billion. So it remains to be seen exactly how that's going to happen, but you know it's potentially good news. So I wrote this slide a couple of weeks ago before Rishi Sunak announced the election will probably happen in the second part of the year. So my question, will it become law before the election? The answer is probably yes. There's no time frame on when it might become law, but there's talk of it being spring. But again, there's no sort of concrete time frame that I'm aware of. Next slide, please. Okay, so what are some of the key changes? As some of you will no doubt know, one of the big headline changes is the role of the data protection officer is going to be scrapped. So there will no longer be a need to have a DPO, and instead it's going to be the obligation. It's going to have will be to have a senior responsible individual for data protection compliance, and the senior responsible individual must be, and I'm quoting from the legislation, it must be someone from the individuals who play significant roles in the making of decisions about how the whole or a substantial part of its activities are to be managed or organized. So clearly it needs to be someone pretty senior. So for example, somebody from your executive group or your senior management team would be able to fulfill the SRI role. Now, in practical terms, the job of the SRI and the job of the DPO are pretty similar. So I don't think there's going to be much change in practice. And also the SRI is able to delegate his or her tasks. So I think in practice what will happen is there'll be somebody appointed at senior level to be the SRI, but the person who's currently the DPO will be able to continue in that role in all factual senses. It's just that they might be called something other than the data protection officer going forward. So I don't think it is a huge change. There's now going to be a much more structured complaints process, in that organizations will be required to have a complaints policy for data protection related complaints. And on the one hand, this may sort of seem like just sort of an extra thing to have to do, but I actually think this is going to be really helpful. And that's because on the complaint work that we advise on, what I often find is that people just almost get sort of caught in this sort of endless loop with the complainant, where the complainant raises a complaint, they get a response, they make another complaint, or they seek clarification, and it just goes on forever. And so having this sort of structured complaints process will sort of make it easier, I think, to sort of bring the complaint to a conclusion and refer them to the ICO at an earlier stage. So DPIAs are going to become an assessment of high risk processing. This may be one of the efficiency savings that the government are talking about, but I would query how much of a difference this will mean in practice. So you'll no longer need to do a DPIA, but you'll need to do an assessment of high risk processing instead. They seem pretty similar to me, but the only difference being you have to you only have to do a summary of what you're doing rather than a systematic description. So maybe they can be a bit shorter, but I don't foresee a huge change there. Next slide, please, Greta. Okay, so my final point then is this: is one of the more interesting changes being brought in by the bill is the definition of personal data is being tweaked. And I really just like to illustrate my point with an example. Imagine you're involved in a research project. You take personal data of study participants. You use that personal data for research purposes. You de-identify the data, so you replace people's names with say a study or a trial ID. Now that information is personal data in your hands because you can match up the trial ID to the individual. But what if you then make that de-identified information available to other institutions for their own research purposes? Do those other institutions need to treat that information as personal data? And the bill is going to tweak the definition of personal data to make it easier to argue that that information wouldn't be personal data in the hands of those recipients. And that's because the focus is going to be on what the controller or processor actually knows. So even if one party can identify people, if someone else can't, if it is unlikely that they'll be able to identify someone by reasonable means, then they're entitled to treat the information not as personal data. So it'll make it easier, I think, to argue things aren't personal data in the context of data sharing in research projects and so on. Have the next slide, please. Another implication of this, also just thinking about contracts generally, is that it'll probably be easier to argue that if you share de-identified personal data with a data processor, that the information won't be personal data in the processor's hands, and therefore will need fewer controller processor contracts possibly. But you still want to be satisfied that that the data isn't personal data. And I expect that if parties are sharing personal data, or sorry, are sharing information on the basis it's not personal data, you still want contractual provisions requiring the other party to sort of still look after the data and not do anything that would be inconsistent with treating it as de-identified. And my final point is even if you can treat the information not as personal data, there may be sort of other wider regulatory or compliance obligations that would mean that you would want to treat it as such. For example, NHS Digital sometimes require parties to information that it provides to people to treat information as personal data, even if it's not technically personal data under data protection law. Okay, next slide, please. Okay, so we've covered that's what we wanted to cover, and I do apologise for that we've overrun slightly. We'll just take a few questions. I'm conscious everyone's probably needs to leave, and then we'll wrap up. So, Bronwen, do you want to tackle a couple on the
Absolutely.
SAR?
Yeah, so we've had one about what to do about former staff members' email accounts. Do you need to investigate with IT to obtain information from this? If there's personal data that falls within the scope of the request that can be found there, then possibly yes. So if a former student made a request, their supervisor has left, but the mailbox is still available, then suggest IT do go and search there. We've also had a question about what about personal data they've already received? So if they're the author or whatever. Again, if that's within the scope of their request, then strictly speaking, yes, you should provide it to them. However, you might want to use the clarification to say you assume that they don't want copies of information they've already received, but let us know if that's not the case. So you can try and get them to agree that they don't want to receive it, because that's probably not what they're looking for. So the law says yes, but maybe use the practicalities to get you to a point where you don't need to provide it. What about opinion? So yes, an opinion can be personal data. It can be mixed personal data between the person who the opinion's about and the person giving the opinion. Whether you need to disclose that is contextual. So looking at the mixed personal data exemption here, the balancing exercise that I mentioned earlier, but yes, opinions can be personal data. A question about what to do with ID that you've obtained to process a SAR. You might want to hang on to that. So the question was, do we delete it? You might want to hang on to it just in case you are challenged in future. For example, if someone says that they hadn't verified the request. So you might want to just be able to prove that you had, and here's the ID that you had. What if people come to view CCTV in person? Should you blur faces? If you can, then great. But I think the fact that you've asked someone to come interview it normally means that the capability isn't there to blur the faces. So if you can't blur them, but someone's just coming in to look at the CCTV, then that's relatively low risk there. But the more you can do to protect people's privacy, the better. And then finally, a question around, is blurring faces on a large scale, so technical redaction, a complicated factor that could indicate a complex request? Possibly, I think, is the answer to this. So sorry, that's not a very definitive answer. It might possibly be considered specialist work in communicating the information in an intelligible format, but it really would depend on the practicalities behind what you were doing and the extent to which you were doing it. I hope that's been helpful on those. Andrew, are there any that you wanted to pick up on?
Yeah, there's just a couple of questions for me. The first one's an interesting one. Some of our courses mean that we need to ask for and process criminal convictions data, and what might be the Schedule 1 lawful basis for that? So that's a really interesting question. So if you're processing criminal conviction data, you need to, in addition to all your other obligations under data protection, you need to find a processing condition from the list, either in Article 9 of the GDPR or in Schedule 1 of the DPA. And the answer as to which condition, it very much depends on why you are collecting the information. For example, we know that some universities will collect information about criminal convictions as part of sort of risk assessing who might be in halls of residence and that sort of thing. And in those sorts of circumstances, there is a gateway, one of the conditions in Schedule 1, one of the substantial public interest conditions, talks about processing necessary to protect either children or vulnerable adults. And it is arguable that a undergraduate student qualifies as a vulnerable adult, even though most of them, if not all of them, will be over the age of 18. There are also general processing conditions in Schedule 1 that reference your functions. So if you feel that your functions extend to sort of safeguarding people on site and so on, then arguably you can rely on one of those conditions as well. So the conditions are definitely there. It's just thinking about specifically why you're using the information and just sort of matching it up to the relevant schedule. We also have a question about the slides, and yes, we'll circulate the URL, the link to the data protection list as part of the follow-up. So that's no problem. Okay, and yes, we'll send out a link. I just responded to Duncan's question. We'll send out a link to the ICO's risk assessment as well. That's no problem. Okay, we're getting loads of questions, which is great. I'm just going to answer one more because I'm conscious everyone probably needs to leave. Actually, I think all the rest for Bronwen. Bronwen, do you want to answer one more, and then we'll wrap it up.
Yeah, absolutely. Sorry, just finding this. The question about employee references being disclosable then. So if you state it's confidential, but the new employer doesn't state it's confidential. So you are responsible for how you treat references in terms of how you would apply the exemption to a subject access request. So if you receive a request and you want to treat it confidentially and apply the exemption, that's fine, even if the other party haven't said, well, we're going to keep it in confidence, because it's about what you do with the reference on your system as data controller. However, it does highlight a slight issue, which is that someone might be able to circumvent this by going to the other party and get the reference in that way, because they might not treat references the same. So just because you're withholding it doesn't necessarily mean that it won't be disclosed by another party.